And again, welcome everybody to today's webinar. Really excited to share this information with you and very thankful for Stephen Rotter that has joined us with the Workplace Council to share this information with you. A lot of great tips and info in regards to the POWR Act. And again, really excited to share this. Please put any questions that you might have in the Q&A box. I'd like to contain it to the Q&A, not in chat, if that makes sense. And we'll go over those. I'll be responding throughout the webinar, and we will answer any at the end that are still outstanding. The other thing I wanted to mention is that you will receive a copy of the recording today, as well as a copy of the slides. And with that, I'm going to turn this over to Stephen.
Great, thanks, Donna. As always, I'd like to thank Obsidian HR and Donna for having me. We've partnered up on a lot of things, so presentations like this, and I learn a lot by preparing for them, which helps me in what I do. And I know, Donna, we've had a lot of discussions over a lot of the material we've covered, which helps us, and I'm sure helps you with what you do. So just by way of background, I've been practicing law for about 18 years now, and for a good part of that, employment law on the employer side. So I help employers create and help develop and help maintain safe, positive workplaces. As part of that, we have to deal with these ever-changing Colorado laws that provide more and more of an onus on employers to make sure that they have safe environments for their workforce, but also that they're compliant with the laws that our legislature develops. So we're here to talk about the POWR Act, and we're going to dive into this. We'd like to make this as interactive as possible. Sometimes it's a little bit harder on Zoom than in person, but we find that if you throw your questions in the Q&A, Donna and I can both monitor those. I think for both the Workplace Council and Obsidian HR, we really focus on the practical application of these laws. So rather than coming to an attorney or your HR consultants or company for theoretical advice and just what options there are, you probably also want practical advice and recommendations. And so while we probably can't get into too many specifics about something that's going on in your workplace, we can certainly talk about the practical application of the POWR Act today. So to begin, Donna and I, what we're going to do today is cover with the POWR Act, the purpose of it, what it really does, and how it applies to you and your workforce. It redefines harassment. It narrows non-disclosure agreements, which, especially over the last few months, now that the POWR Act has gained some traction and more awareness, I've really had to deal with a lot of detail and dive into it with clients to make sure that their agreements are not violating POWR Act terms and provisions. The POWR Act also tightens record-keeping requirements, which you should definitely keep an eye on and make sure that you're compliant with. It addresses disability and marital status. And then we're going to talk a little bit about how to remain compliant, or how to get compliant and remain compliant. So why now? Why did Colorado enact the POWR Act, and why now? The bottom line is that Me Too, Black Lives Matter, and COVID, the pandemic, really shined a brighter spotlight on the longstanding inequities experienced by women and minorities in the U.S. And there was this big climate shift, as I'm sure you've all were aware of and are still aware of, to allowing, encouraging, and supporting women to speak out against sexual harassment and unfair practices in the workplace. This movement started, as you know, really gained traction years ago, around 2017, 2018. And that's when our legislature started thinking about what can we do in Colorado to really have an impact on women being able to voice what's going on in their workplace. And so it took a few years for the POWR Act to work its way through the system. And with the help of sponsors, attorneys, business input, and other interested groups, it was enacted this past August. So what is it exactly? It stands for the Protecting Opportunities and Workers' Rights Act. It went into effect August 7th of last year. It amends provisions of CADA, the Colorado Anti-Discrimination Act, which hopefully you're already all following anyway. This just adds some more meat to it. The POWR Act really targets and aims to address discriminatory harassment and retaliation at the workplace. And the workplace can include your physical office space, working from home, virtual realms, like we're in now, and offsite locations. You guys may know that recently the EEOC issued new guidance on workplace harassment and what it really means, and gave, I think, 77 examples of it. That workplace harassment by the EEOC, it's the first update that they've had on it in 25 years. And part of that has to do with the same thing that we went through with the POWR Act in Colorado. Some things just take a while to go through the government process and get enacted. And really that new guidance did also come out of the Me Too movement and Black Lives Matter and the pandemic. And again, it shined a spotlight on changes that needed to happen. We do have a summary of that guidance on the link below at our blog, so feel free to visit that. But it's important in this day and age, especially with the work from home, to keep in mind that the workplace extends to realms, even virtual realms, other than your offices. And so in turn, provisions of the POWR Act are going to apply as well, especially when we look at harassment, discrimination, and retaliation in the workplace. Donna, were you aware of the new guidance, and have you had a chance to read all 77 examples?
I have not read through them all, actually. But I think that, having new guidance is awesome, because things do need to be updated from time to time. And it gives us a fresh look at really, especially in this kind of thing, or when we're doing training with our employees, it's an opportunity to refresh what we are already doing and make it more powerful.
Yeah, and that's a really good point with the training, and we're going to hit on that again later. But part of workplace training now does have to incorporate that new guidance and the new climate that we're in, right? So I think that's a great point. Okay, so moving on, what is workplace harassment? So the POWR Act uses this phrase, discriminatory or unfair employment practice. That's the basis for violating the law. That's really what the POWR Act is centered around. And then the POWR Act goes forward and details what is and what's not a discriminatory or unfair employment practice. Harassment falls under that broader umbrella of an unfair employment practice and discrimination. It's generally defined as unwelcome conduct directed at an individual because of their protected class or perceived class. So that hasn't really changed much. When we talk about discrimination or harassment, we always have to link it to a protected class, right? Because of they're acting that way, or I'm suffering this conduct because of their protected class or my protected class. All right, so what are protected classes? These should be familiar to all of you. Although if you look at typically under federal and state law, the column on the left, that's what we've seen and what we're used to. Under Colorado law, which is state law, but Colorado has gotten a little bit more detailed and added more classes than many of the states, and certainly more than federal law. And those are listed on the right. It can be hairstyles or creed, your sexual orientation, gender identity, gender expression, pregnancy, childbirth, and related conditions, wage transparency, and that's basically pay equity, and marital status. So be mindful that in Colorado, we do have a more expansive list of what can be a protected class and how someone can be discriminated against because of that class. I think it's also to be mindful that employees that make reports of discrimination, harassment, or they request a reasonable accommodation, right when they do that, they're protected from retaliation against them, right? Because they're reporting something and therefore they retain this, kind of guard or shield around that reporting where they shouldn't be and can't be discriminated or harassed because they made those reports. Okay. So the definition, we highlighted the important words here, grayed out kind of the, redundant stuff. So in the actual statute, basically the POWR Act says this, right? It is to engage in any unwelcome conduct or communication directed at an individual or group of individuals because of a protected class, which is subjectively offensive to the individual alleging harassment, and objectively offensive to a reasonable individual who's a member of the same protected class. That is the POWR Act definition of harassment. That's the new definition that we're under in Colorado. The definition also says, and we put it in parentheses here, but it says it in the statute, it does not need to be severe or pervasive. So what does that mean? Well, the old standard, as we were all used to, it's where the conduct is severe or pervasive, and it's severe or pervasive enough to create a work environment that any reasonable person would consider intimidating, hostile, or abusive. The conduct was also supposed to be, or had to be, subjectively offensive to the victim, the person suffering the alleged harassment, and objectively offensive to a reasonable person, any reasonable person in any class. The new standard, this is the one we're under in Colorado, not federally, but under Colorado. Harassment's unlawful where the conduct is subjectively offensive to the victim. So that's the same, right? And objectively offensive to a reasonable person who is a member of the same protected class. The new standard also recognizes that petty slights, minor annoyances, and lack of manners can constitute harassment if they meet these new standards. That's different as well, right? Because before, and still under the federal law, severe or pervasive doesn't include, in case law, and courts have said, it doesn't include these petty slights or minor annoyances or lack of manners. They can now in Colorado. The courts can also consider totality of the circumstances. So before, the conduct literally had to hit the meaning of severe, which could be one incident of something that's so severe, the person is offended, the victim, and an objective person would say, oh my gosh, it's so severe, that's a violation, that person's been harassed. Now the standard is lower, where a court or fact finder can look at the totality of the circumstances, which we'll come back to in a minute, and really figure out or discern whether or not it constitutes harassment. And again, it has to be subjectively offensive to the victim, hasn't changed, but objectively offensive to a reasonable person who's a member of the same protected class. So why did the legislature change the standard? Well, basically, they said severe or pervasive does not take into account the realities of the workplace or the harm that workplace harassment causes. And the way I think of that too is they're really talking about the modern workplace and what the realities are, because my take is that the legislature looked at this and those who wrote this bill and said, well, the old standard, is it really severe or pervasive if it's over the internet, if it's over Zoom? Is it really severe or pervasive if it's over Slack? During a meeting that two people aren't in the same room, where you don't really feel the body language and you really sometimes can't tell tone, is it really severe or pervasive? And if it's not, well, I guess it's not harassment. What Colorado said was, well, the realities of the workplace, especially in this day and age, severe or pervasive is antiquated. We need to get rid of it. So it's no longer the standard for Colorado workers and employers. Donna, any thoughts on that? The change in the standard here?
I just want to say yikes. I mean, this is pretty big. I mean, we can still look at severe or pervasive, but it doesn't have to be severe or pervasive, which really opens up a lot of more situations. And the fact that those minor annoyances it can now be considered harassment is also, again, yikes, because we know that that happens. We used to be able to say, oh no, you know what, that was a one-off. That was not severe, it was not pervasive. And now, even the comments that somebody makes that maybe it's an emotional comment can now lead to company liability. That's a scary thing.
Yeah, again, great points. I've defended many cases in the past where we have said, well, that's a one-off. It doesn't rise to the level of severe or pervasive. Manager was having a bad day, or someone, is a very sensitive worker, very sensitive person, and they don't like someone else's manners, right? And they say, well, I don't like your manners. Well, before it wasn't severe or pervasive, and also perhaps we could say, hey, that's not linked to a protected class. Here, Donna, as you're pointing out, these petty annoyances or bad manners, someone could take those incidents and say, all right, is it because of my protected class? And if they're the only in a group, meaning the only female or the only Black person or the only person over the age of 40, then they may be able to articulate a viable claim. And that's really all they need for the employer to then have to say, well, we need to do an investigation, find out what's going on here. And so I think the need for investigation, which is in line with what you're saying, Donna, is when you think, yikes, that's when you need to investigate. And it doesn't always have to be a 3-week long, let's interview everyone investigation, right? It can be, let's talk to the complainer, let's find out some facts, let's talk to witnesses, and let's determine and make findings on whether or not it's really because of a protected class.
So, Stephen, there's a great question here in the Q&A, and it just says, would you consider the minor offenses occurring every day for several years harassment?
It depends, right? I know you love that answer from attorneys. And the reason we say that it depends is because, especially in these types of cases and with this change in definition, it's going to be very fact specific, right? But yeah, I mean, if there's minor offenses over the course of time, then it may hit some of the totality of the circumstances, factors that the courts are supposed to look at. And we're going to get to those. So that's a great question. So keep listening because I'm going to address it a bit more. But in short, yeah, I mean, the question is always, is it really linked to a protected class or not? Is this manager behaving that way? Is the company doing these things because of race or color or creed or age, right? All of the protected classes. And if it's not, and you can show that it's not, obviously you're getting out from under that. With petty annoyances, it's a little bit more difficult than a severe comment, right? Or something that reaches that level. So as Donna said, yikes, yeah. I mean, you're definitely going to have to investigate that and figure out if it's a credible claim and figure out if there's something you can do to remediate it. Maybe that employee that's feeling that way and saying these are petty annoyances, maybe they need to be under a different manager. Maybe they need to find a different job within the company. Maybe they're just unhappy for other reasons in their personal lives, which you can't control as an employer, and they're just blaming the company. But those are things that really underlie why you need to investigate.
Yeah, that's why you have to investigate.
Yeah, and promptly.
Yeah.
Okay, so, and we'll get back to that great question too with some of the stuff we're covering here. So the difficulties that we've spotted with this new definition, subjectively offensive to the victim, that's not going to change, right? If someone feels a certain way, they feel a certain way. You can't change that. Objectively offensive to a reasonable individual who's a member of the same protected class. I personally, I don't like this definition. I think it's confusing. I think it's difficult to work with. I think there's the practical reality of this, which we'll talk about. As we said, the subjectively offensive, it's going to be any minor, it could be any minor annoyance or petty slight. It could be. Now, is that credible? Maybe. It depends on the other factors, right? When we're looking at how this is going to play out in court, how do we prove, I said in court, but even if you get an EEOC or CCRD charge, you have to write a position statement, right? And you have to answer the charge and state your side of the case, right? And how do we show that this objectively offensive conduct, how do we show that this conduct is objectively offensive to a member of the same class? Does the fact finder, does the judge or the jury, the CCRD investigator have to be a member of the same class? I mean, how does a judge do that when there's a lawsuit and the plaintiff, the employee says, well, I was offended by this, and everyone that's a member or someone that's reasonably, a reasonable person that's a member of the class would say the same thing. Does that mean then that the employee presents these witnesses at trial that are of the same protected class? So let's say they're over the age of 40. Do they get 2-3 people on the stand that are over the age of 40 to say, yeah, I would have found that offensive as well? And then the employer, the defendant, gets 3 people over the age of 40 that says, well, I'm over the age of 40 and I wouldn't have found that offensive. I don't know how this is going to play out. Again, this came up and was enacted this past August. We haven't seen it in courts yet, as far as I know. But we've seen it with investigations and CCRD charges, right? I mean, it's when you're writing that position statement, do you have to address that? Probably. I mean, in position statements in the past, you would argue this isn't severe or pervasive. Now you have to argue, even though I may not be a member of the class and I'm writing this position statement, I think you have to step in the shoes of someone else. It's not great, right? It's kind of difficult. And then, Donna, you've dealt with this, right? How do we investigate allegations by an individual claiming they're subjectively offended by certain workplace behaviors and they feel harassed? Do we have to interview individuals in their same protected class and say, hey, would you also be offended? Donna, do you have thoughts on that?
Well, I mean, it certainly came to mind. I'm like, do I have to do that? I don't want to. I don't want to go and ask people, that question. But also on the other hand, I want to know if it is offensive to others in that class so that helps me to determine how do I fix this, right? So
I
it's
think
a tough question.
Yeah. And I'm hoping that, the lawmakers and individuals that came up with this language and concept eventually provide some more guidance, some FAQs, some kind of, well, this is what employers are expected to do. From my view, I think the best thing to do, it's a few things here, right? I mean, first off, you need to first investigate the credibility of the subjective feeling. Is it a real claim? Or is it a claim that they made because yesterday they got their annual review and they're unhappy with it, and now they're complaining that they don't like their manager and they feel harassed at work? The timing on that's suspect. It may be true, you have to investigate it. But I think the first thing is examining the credibility of the claim that's made, the subjective side. And you do that by investigating, right? You look at, you talk to them, you gather information, and you look at any documents, you ask for witnesses, and then you talk to those witnesses, and then you talk to the alleged wrongdoer, and you find out what's going on there. And maybe much of the time, that's where it could start and stop. When you're looking at the objectively offensive, I still think we look at a reasonable person, but I think what we have to be more mindful of, and we've talked about this in other seminars and presentations, is perhaps implicit bias and perhaps unconscious bias that we all have. And so that when we're looking at whether or not someone in the same protected class would feel offended by it, that we kind of remove ourselves from the situation and who we are, and look at it from the victim's view, and then perhaps what we can best estimate that protected class's view would be. And I think that's the best we can do with this right now. But at the end of the day, if you're doing the investigation and you care about your workforce and you're showing that you're going to remediate harm in the workplace, even if it doesn't rise to the level of harassment, you need to do something about it and you need to address it. And if you're doing that, you're doing the right things and you're doing it in good faith. And I think for now that's really good. And I think that's going to solve a lot of these issues. So keep in mind too that here's another issue. The POWR Act does not supersede federal standards, right? So when you have an employee that comes with claims under the EEOC, to the EEOC and the CCRD, the Colorado Civil Rights Division, so it's both under Title VII, the federal law, and it's under CADA, the Colorado Anti-Discrimination Act. What standard do you use there? Because if the EEOC investigates it, are they going to implement Colorado standard, even though they've intertwined CADA? If it's a CCRD investigating it, are they going to look at, federal standards and use severe and pervasive? They're likely going to use the most stringent standard, which is the new CADA standard, the POWR Act standard, objectively to the victim, subjectively to someone in the same class. So when you're writing your position statements or investigating or defending, you probably want to look at and do that under the eyes of the POWR Act and what the expectations are. So coming back to kind of the question about, what are petty annoyances over the course of years, would that rise to the level? It can. The legislature gave a little bit of an out here for defending against claims because you can look at the totality of the circumstances here. And I think that's very helpful for employers, because then you can argue that these factors weren't in place, or at least some of them weren't in place, and it didn't rise to harassment. So how frequent was the conduct? How many individuals were involved? What was the nature of that conduct, right? Was it severe or pervasive? How long did it last? I guess the third is severe now, and the fourth is pervasive, put another way. Where was the location of the behavior? Was it in person? Was it online? Was it at an offsite? Was it at a company function where everyone was drinking and behaving inappropriately? Could the conduct be considered threatening? I think that's a very important factor in this day and age, because I think we often hear now that people feel like they want to be in a safe workplace. And I think that employers are more attuned to that and really try to create this environment where people don't feel threatened in the workplace, right? Is there a power differential between the wrongdoer and the victim? This is a lot like quid pro quo harassment, where there is a disparity in power that exists. And, if it's coworker, that's different, right, than if it's manager coworker, because that power disparity. Was there a use of slurs? I think that goes to how severe the conduct may have been. Could the conduct be considered degrading? Which is different than someone telling inappropriate jokes, perhaps, which may not be threatening or degrading, but could fall into these other categories, right? Someone that always tells bad jokes that are sexist or racist or ageist. I mean, that now doesn't need to rise to the level of severe or pervasive. And that manager may need either a talking to or training or separation. And then the 10th factor is, does that behavior or the conduct reflect stereotypes? So is someone treating someone a certain way because of stereotypes that they've, it reflects certain stereotypes about people. And that can also go back to implicit bias.
So, Stephen, some of these factors are subjective. Especially I'm thinking about the degrading one. So, I mean, certainly the person that made that complaint to you or told you about the behaviors, they are likely to see that as degrading. So what kind of things would you take into account to answer that question that would make it more objective?
Right. It's probably going to be the other 8 or 9 factors, right? It's going to be who's it coming from? Is there a power disparity? It's going to be situational.
Mhm.
And, you know, when we think of reasonable person, what we're really talking about is if like a blank slate, looking at it that way, if they were in that, if you were a blank slate and in that position, would you objectively look at that as being degrading? Um, and then you have to add the twist though now with the POWR Act of, well, what if I were the same protected class? And that's what the comment is about, right? And so you're taking those two parts and kind of putting them together to see if it's objectively offensive to someone in their shoes.
Thank you.
Yeah. Okay. We mentioned this, we wanted to put this in here, but harassment, you can also lodge a harassment claim for quid pro quo conduct, which is that the bad conduct is made a term or condition of employment, and either submission or rejection of the conduct is a basis for an employment decision, right? So, go across the street with me, we're going to get a drink. It's a hotel bar. Maybe we can get a room and maybe you'll get that promotion, right? Or the bad conduct has the purpose or effect of interfering with performance, which is typically feeling harassed at work. I'm using the same word as the definition, but it's unwelcome conduct directed at you, and you feel like you can't perform your job properly because this person keeps doing it. And it's typically manager to subordinate. And I know, Donna, we've talked before about, in this day and age, what really counts? Does it have to be, hey, I'm taking you across the street to the hotel room and then you get the promotion? We've talked about that, but what are your thoughts?
Yeah, I mean, I think that this bad conduct can be any number of things. And, I think about the person that is subjected to sexual or gender nicknames, sweetheart, sugar, honey, and they have objected to that, and yet it continues, and it has become a, hey, if you make a complaint about this, or if you tell anyone, then you're going to be punished in some way, right? So it might be that term or condition of employment where you lose your job, but it could also be, I'm going to reduce your schedule. I'm going to change the benefits that you're eligible for. Other basis of those employment decisions, I'm not going to consider you for promotion, because you're objecting to this behavior. And, it's so broad because these things happen in the workplace. I have to laugh about that because we have to be real. People do use inappropriate terminology in the workplace. And so when does it cross into this quid pro quo? When is it now, according to the person receiving that behavior, they believe and they, have reason to believe that it's either affecting their performance or it's the basis for employment decisions.
Yeah. And, as we talked about at the beginning, the EOC guidance addresses this as well. And that's why they have 77 examples. And that's why it's changed. Our climate has changed a lot. And it's harder for employers, as a matter of public policy and like wanting to be in a community that cares about workforces. It's supposed to be a good thing. I think for employers, it's more difficult to navigate. And maybe they do have to pay more attention to these petty annoyances or to minor comments and to do these investigations. And as I said, and I'm happy to talk about this anytime, but investigations don't always have to be this 2-3 week long, we interview 20 people type of thing. It can be as short as like a 2-hour thing where you call or talk to or interview the complainer, and then you go from there. Are there witnesses? And then you talk to the alleged wrongdoer and you make findings, and then you make a recommendation either to the business side or to upper management or to whoever you need to make a recommendation to, or you make the decision and you're the decision maker, and you follow through with what you think the best thing is based on those findings. And one thing to remember, and I've run into this a couple times over the last couple of months with some cases, at the time that the decision maker, the employer, made their decision, they had a good faith belief that A was true, when in actuality, B was true. But courts don't hold employers responsible for not knowing B if they made a good faith effort at investigation and remediation, and they had a good reason to believe A was true. So as long as you're doing something, you're headed in the right direction. Okay, so affirmative defenses, which is kind of what we're talking about. What do employers need to implement to protect the company from future claims or to provide a defense to a charge or lawsuit? You have to have a program in place designed to prevent harassment and protect employees. That program consists of these following things. You have to promptly investigate complaints. I think we talked about that a little bit, right? You have to respond with remedial action. You can't just investigate and leave it hanging. You have to figure out what you're going to do to remediate the problem. And sometimes it may be something minor. It may be something like training. Not that training's minor, but it could be something minor. It could be training. It could be a change in, a job or location for someone. It could be separation. You have to communicate this program to the workforce. So basically, what the POWR Act is requiring is to make sure that your employee handbooks and policies are updated to show and to state that we're anti-harassment. If you see something, say something. So report it. Here's who you report it to. We're going to investigate it. If you report it, we have anti-retaliation policies. Don't worry, you're not going to be retaliated against. Whether or not employees believe that is one thing, and you can't really control that some of the time. Some of the time you can by making sure that you have open door policies, good communication, and that you do these things. You promptly investigate and you take remedial action. So communicating that program to the workforce is part of this program that the POWR Act requires. A defense then is, well, we had this program in place, we did these things, and the employee didn't take advantage of it. They never reported to us, and if you don't know, how can you do anything about it, right? So that's the defense. As we touched on earlier, the best way to prevent harassment in the workplace is making sure you have a strong corporate culture. So that's really designing and acting in ways and training management to act in ways that follow the values of your company, and that flows down to the employees. Making sure there's open lines of communication, making sure that bad behavior is reported, and then identifying and correcting conduct before it gets to harassment. All right, so next topic is non-disclosure agreements. So what's a non-disclosure agreement or provision? The POWR Act defines NDAs, or non-disclosure agreements, as provisions limiting an employee's ability to disclose or discuss any alleged discriminatory or unfair employment practice. As we talked about at the beginning, this was born out of really the Me Too movement and Black Lives Matter, and the ability for women and people of color to be able to talk about what their experience in the workplace without feeling like they're going to be retaliated against. And it's making sure that we support them to address ongoing issues that have been going on forever. So typically we see NDAs and settlement agreements, severance agreements, invention assignment agreements, confidentiality agreements, non-competes, non-solicits. So sometimes they are standalone agreements, but oftentimes it's just a paragraph in these, right? And those are the paragraphs that we need to address now and make sure that they're compliant with the POWR Act. And on that note, I actually looked at an agreement before this presentation today, and it did not incorporate the provisions correctly of the POWR Act. And so I had to make a lot of changes to it. And we'll get into why that's bad, but because this law is so new, you really have to go look at all these agreements and ensure that they follow the POWR Act. And I don't know if it's good enough to say in these agreements, you can't disparage, discuss, and you got to stay confidential forevermore, except for the POWR Act provision stuff. To me, that still creates this chilling effect on employees' ability to talk about things in the workplace. And at some point, the EEOC could find that that violates, or the NLRB, if it's a Section 7 violation, that it really violates the purpose and the point of making sure that you specify what you can and can't have, which we're going to get to in a second. There is overlap between non-disclosure and non-disparagement, which we'll see. So be mindful of non-disparagement as well. So here are the 4 or 5 things that the POWR Act said NDAs are void unless you do this, right? So any agreement that contains an NDA or they're renewed after they were either entered into or renewed around August 7th, 2023. I said around August 7th. It's after August 7th. You're used to saying on or about, right? So after August 7th, limiting the ability to discuss any alleged discriminatory or unfair employment practice are void unless they have the following. They have to apply to both the employer and the employee. You can't just say to the employee, you're not going to disclose this. We can say whatever we want. POWR Act says, nope, it's got to apply to both parties. It also says that if the employer does go out and disparage the employee, they cannot later on seek damages or enforce the non-disparagement against the employee if the employee then decides to disparage the company. I do want to say something here that I think is pretty important when we think about disparagement and non-disclosures. As a matter of law, you can't defame an employee and an employee can't defame the employer. And that really means to publish or say something that is untrue and derogatory that might damage either the employer or the employee. So that's already a law we have in place, which to me kind of lessens the need to have non-disclosure and non-disparagement. I'm not saying that we shouldn't have them, but I think we need to be mindful. And I always remind my clients, well, they can't defame you no matter what. If they say something that's untrue, then you can go after them or you can cease and desist, right? Send a letter. If they say something that's true, even if it's a negative thing, they're allowed to talk about the terms and conditions of employment under Section 7 of the NLRB, right? You can't create a chilling effect or stop employees from talking about this stuff. They can if they want, and they can do it on social media. They can do it after they leave. They can post it on Glassdoor. If it's untrue, they can't do it. So keeping in mind that with the Section 7 NLRB rights and the defamation, the common law definition out there and use of it, I don't know how important putting these non-disclosure, non-disparagement provisions and agreements really are. And I know I'm jumping ahead here because we're going to go through, but I wanted to mention that. So we have to make sure they're mutual. These agreements are void unless they allow. So you can't restrain an employee from disclosing the underlying facts of the alleged discriminatory or unfair employment practices to the following individuals: immediate family members, religious advisors, medical or mental health providers, mental or behavioral health therapeutic support groups. And Donna, you and I talked about this before where, there's times when there may be 2 or 3 women that have alleged that there is sexism or they're being discriminated against or harassed because of their gender. And they text each other. They get on a group chain and text, or they're on a Facebook page together or Insta or whatever they do. That could be considered their mental health therapeutic support group. And so if one of those women want to talk to another woman or person that's part of their group, you can't stop them from doing that. They can talk about the discriminatory or unfair practices. That's my take on it. You can always talk to your attorney about what's ever on your mind. We're therapists in a way, right? You talk to your financial advisors. You can also talk to your tax preparer, which not exactly why alleged victims or victims of discrimination are talking to their tax preparers about what's going on in their workplace, but you can. Go ahead, Donna.
No, I was just going to say, I think that the term therapeutic support group opens this up to all kinds of people, you know, because, you know, your support group can be your neighbor.
Right. Well, that's right. Yeah, I agree. And so I think the point here is employees are going to talk to, and former employees are going to talk to who they talk to. And it's hard to stop them to begin with. And these agreements now, you specifically have to state in there these things, that it doesn't do this. You also have to state in there that it doesn't constitute disparagement if you disclose those underlying facts to these individuals. So you can't come after them for disparaging if they disclose, you know, underlying facts of what they feel was discriminatory behavior. The agreements are also void unless if they have a liquidated damages clause, it has to be tied to actual anticipated loss and be reasonable, the nature of the breach. It can't be punitive. And then this is a weird one too. At the end of the NDA, the agreement, or an agreement that contains an NDA. So today I had a settlement agreement, like I said, that I looked at, went through it, had to incorporate some of the POWR Act stuff. At the end, there was an addendum for both parties to sign, saying that it complies with the POWR Act. I have no clue how, at least for me, most employers and most people in HR or management or employees know whether or not it complies with the POWR Act. I have no clue why it's in there. Maybe it's to be on notice that it's supposed to be in there. So, you know, we discussed some of these things already, and for the sake of time, I'm going to leave them out there. You know, the only one we didn't touch on is what's an immediate family member. Under most definitions, it's someone that's close to you. And under a lot of definitions, it could be a friend, it could be a partner, it could be your best friend, it could be your pet.
Yep. So there's a question here, Stephen. It just says, to clarify, the NDA provisions only apply to situations, agreements when allegations of discrimination or harassment, or is it all NDAs in general?
Right. So my understanding is that for any non-disclosure agreement that you have where you're asking an employee not to share certain things that happen at work, that you have to include it. If you're preventing them from talking, if you want them to not disparage the company and not disclose, you know, stuff that happened at work, then you have to include it. So if you don't include it, it's $5,000 per violation. The employee, if you either don't include it or you violate it, here are the damages. The punitive damages one is for if there's a pattern of conduct by a manager repeatedly, and the company keeps trying to cover it up by giving each of the victims an NDA and saying, don't disclose, don't disclose. Now, under the POWR Act, someone could take those other NDAs, bring them to the court and say, well, I should get punitive damages. The purpose of punitive damages is to punish the company. So that's about the person and their claim, and it's punishing the company. We're going to fine you $10 million, which really cripples you because you didn't stop this pattern of conduct. The weird thing is if they're all NDAs that these, let's say it's a group of women that feel like that they have got or over the age of 40, or it's a race-based claim. How do you know these NDAs exist to bring them in front of the court? I'm not sure, because nobody's supposed to be talking about them, but you know. Just a few other things.
Part of that therapeutic group, Stephen.
Right, it's a therapeutic group. It could be, yeah. All right, for the sake of time, we're going to go through this again a little bit quickly. So for record keeping, you are now required to keep a repository of all discriminatory or unfair practice complaints. So what does that mean? Well, one, you can use a spreadsheet or folder, electronic or physical, or HR software to keep these complaints. It includes any written or oral complaints. So if someone comes to you and says, I feel like I'm being discriminated against by manager A, you got to write that down and put it in the repository. Even if it's untrue, even if you investigate it and find out that it was just a made-up lie, you got to keep a repository. you've got to put in the identity of the complaining party, the alleged perpetrator, and the substance of the complaint. One issue that Donna, you and I have talked about with this is if people don't like a manager, or someone just has an issue with them and kind of spreads gossip about them, and you keep getting complaints about manager A, and now in the file, you have manager A did this, was alleged to have done this, manager A was alleged to have done that. Is that fair for manager A if he didn't actually do anything and people are either sensitive or they don't like him, or it's, especially if it's not tied to a protected class and that's the reason for manager A's conduct. It's not discoverable under core requests, this repository, but it kind of slides towards erring almost too much on the side of allegations, especially when they haven't been investigated and you don't know if they're true. Seems to me that this is fairer if you do the investigation and there's at least some truth to it, or it can be a viable claim. That's when you record them. But that's not the current law. So if someone makes a complaint, you have to do those things. Do we have questions on that before I move on? Is there a difference made for NDAs to employees versus NDAs? No. The definition of employee under the POWR Act can and typically includes contractors as well. What if the manager is also an owner? They can be held liable. I'm not sure if I completely understand that, but they can be held liable for personally, if that's what you're asking about under CADA, for sexual harassment and other forms of harassment.
Yeah, and I think, Stephen, that actually refers to this record keeping. And so I did respond to that as well. And I just said, if there's any allegation, you have to record it, regardless of who it's against. So
Yeah.
even if that is the owner that complaints are coming up against, you still have to put that in that spreadsheet.
100%. Sorry. Yeah, that's exactly right. I'm glad you're on this. Okay. And then for record keeping, you have to keep records for 5 years from the latest date the record was made, a personnel decision was issued, or the resolution of discrimination charge or lawsuit for any of these things. So it's accommodation requests, complaints we talked about, employment applications. You have to keep records related to hiring and training records. Going back to the complaints of discrimination and harassment, if someone makes a complaint today, May 22nd of 2024, and you finally get through the whole EEOC and lawsuit process on May 22nd of 2029, that's when the 5 years starts. So now you're keeping that, you got to keep the records from everything for the next 5 years and then 5 years past. So disability, minor change here. Probably should have been this way all along, but the standard is modified to mirror the federal ADA. So it is not a discriminatory or unfair employment practice to take an adverse action against, it's supposed to say an individual. Sorry, I meant to change that. Not and an individual, but an individual with a disability if no reasonable accommodation can be made that would allow the individual to satisfy the essential functions of the job. Always link the accommodation request and your interactive process with the essential functions of the job. Whether you use the job duties that are printed out and provided in your job postings, or were given to the employee, or are on some system somewhere. And again, it's very helpful. We always say document to make sure that you have that somewhere, those essential job duties. If you find that you can't accommodate this person because it's an undue burden or because of impossibility of the job, then you can't accommodate. I mean, that's all you can do. So what are typical reasonable accommodations? Can you modify their work schedule? If you're modifying the work schedule so much that another worker has to take on the duties and now they're working 40, 50, 60 hours a week, 40 hours, I guess is fine. But if they're working a lot more, that would be an undue burden. Consider changing their position, modifying training materials, and make sure that they're accommodated by way if they need, if they're hard of hearing or they have sight issues, that there are interpreters or assistants. Another thing to keep in mind in this, especially in this day and age, is mental health accommodation. It's a little bit more nebulous, right? It's a little bit more vague and difficult to pin down. It's one thing if someone has a broken arm and they can't do like a moving job, It's another thing if someone comes to you with mental health issues, you go back to them and you say, we need something more specific from your provider, if you do, and then you go from there and you do the interactive process. Okay, what's an undue burden? It could be cost too much to try and accommodate them. Your business may be small and it's really hard for you to have the resources to make this accommodation. You're not required to. You're required to go through the interactive process and evaluate whether or not you can and work with the person. You may not have the resources, or it might be the impossibility, right? I had a case where I had to say, hey, it was a mental health issue with this employee, and the attorney kept coming back to me and saying, well, they didn't even try, they didn't do this, they didn't do that. And I said, well, anything they would have done according to the accommodation that person needed would have violated what they were asking for, and put this individual who was triggered by his manager even talking to him. And I said, it's like this. If you own a moving company, someone breaks their arms and legs, and then you tell them they got to come in the next day and move boxes, and they don't do it, and then you fire them, it's an impossibility, right? They can't come in and move boxes. So sometimes it just might be impossible. Marital status is now protected under CADA. So just keep in mind, don't consider marital status when you're deciding on personnel actions. She probably doesn't want to travel because she's married, or we shouldn't give him the promotion. He just got married and he doesn't have the same time that he used to on his hands. So he's not gonna be able to do this job, right? Okay, so for next steps, and we've covered this, update your handbooks, train your workforce, make sure management and HR are focused on responsibilities for complaint reporting procedures. Your workforce, your employees, you want them to know these new definitions, and so you want them in your handbook. I've helped employers, and I'm sure, Donna, you guys have too, with replacing the severe and pervasive language either in handbooks or making sure you include these new definitions. Definitely have in the handbook how to report complaints or your policy, and that I always put in there that employees are obligated to report. They're obligated, if they see something, say something, and that they're obligated to participate in investigations. You should tell them that they're obligated to participate in investigations for two reasons. One, so you know what's going on with your workforce and you can investigate and remediate action. And two, you don't want them to feel like, oh, well, you want to make sure that they know they don't have a choice. They have to participate in the investigation. That way there's no out and there's no retaliation, right? So if someone says, well, you told on me, say, well, I had to. I was obligated to. Whoops, sorry. This is the last part. Make sure you've got the record keeping compliance, and really consider removing non-disclosure or non-disparagement provisions if you don't really need them based on the factors we talked about. All right, any questions?
I think that's just, I'm working on this last question about, there's someone requesting an accommodation about working from home. And that was the last one. And so I think we're good. I mean, I will finish this, giving you this written response for that, whoever wrote it.
Well, I'm happy to briefly address it. It's going to be like
Sure.
any other accommodation. You're going to take into factors whether or not it's an undue burden for your company in reality. A court's going to say, hey, first of all, how long do they need to work from home? Secondly, why? Third, would working from home really solve what they're looking for? Or are they just looking to work from home because, they like watching ESPN during the day and taking naps? So really find out why. And then if it's a medical need, then you push back and you make sure that you get them to go to their medical provider and provide reasons for it. And the medical provider should provide the reasons why they need it and suggested accommodations, and then assess it. And if you can do it, and a reasonable person or a court would say, well, you could have done it, then you probably should do it, even if no one else is working from home. That's not the comparison, right? The comparison, the analysis is it an undue burden, or should we be doing this or not? And why are they asking for it?
Great, thank you.
Yeah, well, thanks everyone. Hopefully that was helpful. Sorry I rushed through a couple things, but I'm available. Donna's available. Obsidian HR is available. So please reach out at any time and enjoy the rest of your Wednesday. It looks beautiful out. I'm going for a walk. You know, take care.
All right, thanks, everyone. We'll be sending out the, again, the copy of today's slides as well as the recording for today's webinar. Be sending that out later today or the latest tomorrow. And thank you again for attending. Very much enjoyed it. Thank you, Stephen, for all of your expertise. As always, it's a pleasure working with you. And
Likewise. Thank you, Donna.
yeah, any additional questions, you guys just let us know. You can email me at help@obsidianhr.com and happy to provide additional information. All right, take care, everyone. Have a great day.